Let's talk about wills. We call it a last will and testament, but the purpose of the will is to say who inherits your assets if you die. So there's basically several ways you can make a will. Primarily, you can make it the right way or the wrong way. Now, one of the ways that you can make a will in Arizona, if you're an Arizona resident, is you can sign a typed document that is notarized and that is witnessed by two people who are unrelated to you. So those witnesses have to be present and see you sign your will. So that then is a legally enforceable will. Now, another way you can create a will is by writing it in your own handwriting. So if you have a document that you've created and the only thing on that document is your handwriting and it says what you want to happen to one or more of your assets, then that also is a valid will. For example, you could say in your handwritten will, if I die, I give my house to my sister. Or you could say, if I die, I give all my property to my children equally. So you can pick and choose who inherits what, but you have to write it out and describe it in the handwritten document. So that 100% handwritten document signed by you can be a valid will in Arizona. So if you have a will in Arizona and you die, then the family must first make an inventory of your assets. That means that they need to see how much do you own in personal property and how much do you own in real estate. If you own less than $75,000 in personal property, then you don't need to do a probate for your personal property. You can do an affidavit of exemption, and that avoids a probate for the personal property. You have less than $100,000 in real estate, you don't need to do a probate for that either. You can do another affidavit to avoid probate for the real estate under $100,000. So if you don't have assets that exceed $75,000 in personal property and $100,000 in real estate, then you have to do a probate. And what a probate is, it's a superior court proceeding where somebody applies to be a personal representative. That's the person who's in charge of collecting the assets, paying the debts, and then distributing the assets to the heirs. So the probate then will follow the instructions in your will, and the job of the personal representative is to give the assets in your estate as directed in the will. Now, a probate in Arizona typically takes us about 5 months. We charge around $3,500 for an uncontested probate. We have to file a notice in a newspaper, and creditors have 4 months to make a claim against the estate. But if no claims are made, then we're going to terminate the probate in month 5. So it's not a terribly difficult thing. It's just a little bit of a pain in the neck. So it can be avoided entirely, and that expense can be avoided if you have a trust. Then the assets that you own are in the trust and they don't go through probate on your death. They just automatically transfer to the person or people you've named in your trust agreement. All right, let's talk about the difference between a revocable and an irrevocable trust. The primary difference is that irrevocable trusts cannot be amended unless there's language in the trust agreement that authorizes it or unless a court approves a change. Typically, we don't create irrevocable trusts for our clients when they do an estate plan. We do a revocable trust because people want to change their trust as things change in their life. Over time, there's going to be changes. Maybe somebody dies, or maybe you decide you don't want this person to be a successor trustee, or you have another person you'd rather be the successor trustee, or maybe you want to disinherit somebody. So with a revocable trust, you can update it and make changes over time as things change in your life. The problem with an irrevocable trust is basically you can't change it except in rare situations. Maybe there's a provision in the agreement that allows a change, or maybe beneficiaries have to go to court and ask the court to change it. We like to prepare irrevocable trusts for the beneficiaries of our clients' estate planning trusts. But one of the types of trusts that we do create is called an irrevocable asset protected trust. Like we have people, for example, that have a lot of net worth and they want to transfer some of that value to their children and get that out of their estate so it's no longer taxable. So what we can do is we can create an irrevocable asset protected lifetime beneficiary controlled asset protected trust The child is the beneficiary. The parent can decide should the child be a trustee or not be a trustee. But at the end of the day, what happens is the parent may put 2 million, 5 million, 10 million, whatever it is, they put that amount of value into the irrevocable trust. The first thing that happens is it takes that value out of the estate of the parent. So the parent's not going to have that added into their estate and determining their liability for federal estate tax. But the other thing it does is it makes those assets that are now indirectly owned by the child asset protected for life. So the child can benefit from those assets. Now, we see this a lot with parents that have businesses that grow in value. One of the benefits of having interest in a business transferred to a child is it not only allows the future appreciation to be recognized by the child's trust, but it also avoids a future appreciation on estate tax for the parents. Now, the best estate tax planner ever was Sam Walton, because when he created his first Walmart store, he made it a partnership. That was back, I think, in the 50s, for LLCs. And so what he did was he had, there was 5 partners of his partnership, and Sam and his wife owned 20%, and each of his children who were minors owned 20%. That grew and became, the Walton's family investment in Walmart, 100 billion plus. And 80% of that was outside the estate of the parents because they had given 80% of the company away to their children, when they first formed the company. So irrevocable and revocable trust, 2 different types of trust. Now, in our irrevocable trust, we put in a clause that's called the trust protector clause that gives the family or the beneficiaries, that gives the beneficiary the ability to ask the Superior Court to appoint a trust protector who has the ability to modify the trust, to make changes to the irrevocable trust, to deal with changes in the law that affect the trust. A trust, whether it's revocable or irrevocable, has a trustee or maybe 2 trustees who act as co-trustees. The duty of the trustee is to follow the instructions set forth in the written trust agreement. And the trustee has fiduciary duties. That means that the trustee is held to a higher standard. If the trustee breaches a fiduciary duty, then the trustee can be sued and the trustee can be liable. So the first thing about trustees is they need to be designated in the trust, and they also need to sign a document where the trustee agrees to be the trustee. Because I can name Homer Simpson as trustee in my trust, but if I don't get Homer to sign that trust as a trustee, he's not the trustee. So the trustee needs to sign the trust agreement and agree to be bound by the legal obligations in the trust agreement. Now, in Arizona, a company can't be a trustee unless it's licensed as a trust company, but any individual can be a trustee. So it's very common for parents to pick 1 or more children to be successor trustees or trustees of their own trust when the children inherits the assets from the parents. But when there's a person acting as trustee who's not the beneficiary, in other words, let's say parent creates trust for 2 children, and sister owns is one of the beneficiaries and brother is the other beneficiary. So the parents don't think that the sister should be controlling her inheritance because she would make bad decisions and cause a loss in value. So the parents name the brother as the trustee of sister's trust. Now that means because the brother has trustee obligations, he's actually potentially going to be liable if he does something wrong. And one of the things that he can do wrong is make a bad investment. So if brother takes stock invested in FTX or whatever, and then loses the value of that stock, brother can be sued by sister because the brother as trustee made a bad investment and caused a loss of the sister's trust assets. So that's one of the risks in being a trustee, that you have liability to the beneficiaries if you don't carry out the obligations in the trust agreement or if you breach any fiduciary duty. We usually provide in our trust agreement, or we always provide, that the trustee is entitled to reasonable compensation. But trustee compensation is entirely determined by the trustee, with the risk that if the trustee overpays him or himself or herself, the beneficiary might sue. Now, Arizona law says that beneficiaries of a trust are entitled to get information about the trust and their assets and rights under the trust agreement. So people who are not beneficiaries of the trust are not entitled to get any information from the trustee about the trust. Only the beneficiary is entitled to that. And the trustee should keep excellent records and give a report to the beneficiary every year showing income or the state of the assets, how much the assets have earned or grown in value, the expenses, what's the amount of the expenses, and just keep the beneficiary informed of the financial status of the assets in the trust. So another consideration is using a trust company like Trust Bank. These trust companies like Northern Trust, Trust Bank, they've been in the business for years of managing trusts and acting as trustees for multi-million-dollar estates and dealing with people. So that's their business. I'm a big fan of the corporate trust company, especially when you're talking about a lot of money that needs to be managed. Because let's face it, most people don't know how to manage money, and it might be a better idea to have Trust Bank be the trustee and invest the assets of a trust. My son and I, Richard C. Keyt, we're both estate planning attorneys. We prepare wills, trusts, and all the ancillary documents that go into an estate plan. And we are always happy to answer questions about wills, trusts, estate planning. We offer a free consultation to Arizona residents. We only do estate plans for Arizona residents. But if you'd like to get a free consultation, go to our online calendar. It's at www.KEYTLaw.com. And there you can book a time for an in-office, a phone call, or a Zoom video conference to answer your questions about wills and trusts and estate planning. So that's the first step to getting your estate plan and protecting your loved ones.